And Chris, you're not going to believe this, okay? Sometimes the other party will lie. Have you heard of?
I mean,
Have you,
I rock. I'm not at all.
I know so I explained that to the client. I mean, even if the goods were completely perfect and the defendant used them and never returned them and never complained, I mean, all the defendant has to do is sign an affidavit that's probably a lie that says something like, I ordered blue widgets and you shipped me green widgets, right? So, and there goes your summary judgment motion. Welcome to episode 112 of the Weekly Docket, a podcast by the Silberman Law Firm, where we talk legal news and practical law. Today is March 6, 2026. I'm Phil Silberman, owner of the firm and your host, and I'm joined by Chris Hield, who's our firm's supervising attorney. Chris, we have a really boring show today. We are going to do one thing, and we're going to do that one thing well. And we're just going to talk about summary judgments in Texas. That's all we're doing. Okay.
Well, we got some new rules, so that's not boring. No.
Well, it's, we do have a lot of attorney listeners, a lot of politicians. I mean, the show kind of leans a little bit, to that type of listener, but I'm sure there's a lot of other people that listen to. So for those other people, I'm not sure how boring this will be. So on our docket today, within the summary judgment framework, we're going to answer a question. What is a summary judgment in Texas? What evidence do you submit with your summary judgment? And then the two types, no evidence versus traditional. We'll talk a little bit about that. And then we will look at the rule changes that took effect on March 1st, and we'll explain those. So let's go ahead and get it kicked off with just the general stuff. I'm going to let you talk a little bit about this. If you were telling your friend who's not a lawyer, what is a summary judgment in Texas? How would you explain that?
To a layperson, I would say summary judgment just means you're asking the court to determine that either your opponent's case is so bad or weak or nonsensical, or that your case is just so obvious that without a trial, you're asking the court to decide the matter in your favor.
Yeah. So it's designed for lawsuits where allegedly there's no factual disputes for a jury to decide. In Texas, the rules generally governed by Rule 166A of the Texas Rules of Civil Procedure. When we were in law school, or even still today, for young associates, I still tell them it's a trial on paper. Have you heard that term before?
Probably from you.
Okay. And what that really means is your pleadings are frozen in time when you go to that summary judgment hearing. All that can be considered are the pleadings and your summary judgment evidence, and the judge has to make a decision based on those documents. Talking about evidence, when you're submitting a summary judgment, what kind of evidence do you typically want to put on the with the summary judgment? What kind of evidence do you want to include, Chris?
Well, if it's a no evidence summary judgment, you're not allowed to produce any evidence. You're saying the other side has no evidence of their claims. If it's a traditional summary judgment, then you're saying I'm going to present facts, evidence that can't be refuted. And so you would attach affidavits, you would attach your documents, whatever those may be. If it's a breach of contract, you say, here's the invoices, here's what is owed to me. There's no dispute, didn't pay. Here's my affidavit saying he didn't pay. Here's the invoice for the non-payment. And here's proof that I produced the goods. Mm-hmm. There's no fact issue here. I gave him the goods, didn't pay me money. He owes me money. Judge, tell him he needs to pay me money.
Yeah. And importantly, I think people, even young attorneys, miss this. There's no live testimony at a summary judgment hearing. I think people get that confused. So
well, we think what we say carries weight. So we think that as attorneys, when we speak, we carry the weight that is, worthy of evidentiary value.
Right. But yeah, so you don't get to call witnesses. Your documents, your discovery, your affidavits kind of have to speak by themselves. Now, you talked a little bit about no evidence versus traditional. I want to expand on that a little bit. What's the difference? Traditional summary judgment, that's 160 rule 166A and then C like Charlie. And in a traditional motion, the party filing, the movant bears the burden of proof. To win, they've got to show that there's no genuine issue of material fact. Okay, meaning the important facts aren't really in dispute, and they're entitled to judgment as a matter of law based on those undisputed facts. Um, it's not as common as you might think, right? To win on summary judgment in that regard, but it does happen. Um, I had a summary judgment case where this was it was actually a car accident case. It was a negligent entrustment of a motor vehicle case, and I was representing the party being sued who allegedly loaned the vehicle to the person in the car accident, and it turned out that it was very clear that the vehicle was a sale, or it was by sale. And I actually had an affidavit of the guy who bought the vehicle saying, he didn't loan the vehicle. The guy you're suing didn't loan the vehicle to me. I bought the vehicle from him, right? So I filed the traditional motion for summary judgment, and the other side just, instead of, I guess, going through the embarrassment of losing, they just non-suited, right? But I felt like that was a pretty solid traditional motion for summary judgment, right? So,
I'm still surprised. People dig in, lawyers especially. They dig in and they say, "No, you don't know that. I don't know that.
mm,
I need discovery. I need a jury to tell me that.
mm,
I'm not going to word for it."
yeah. But we have a lot of clients that call us, Chris, and how are you going to get my case dismissed? File a summary judgment, and what is your response to them? Because most cases aren't appropriate for summary judgment motions, right?
No, I agree. And a lot of people that hire us do not have unlimited money. If you do have unlimited money, please call us. But if you don't have unlimited money, summary judgments can be beneficial. Even if you don't win, there are always things to gain. One, you could get a partial summary judgment. If you don't win the whole thing,
Mm,
you could win certain claims or you could win part certain claims. But the flip side of that is judges don't love summary judgment. Judges don't love default judgments. They don't love summary judgments. And a lot of times they will punt.
mm,
And even if you have a good case, if we file a summary judgment and it isn't granted, doesn't mean the other side wins the case,
mm,
but it means the judge is looking at you and saying, well, your case isn't that obvious. Your case isn't a slam dunk, as a
mm,
lot of people like to use that term. And so the other side walks out of that courtroom feeling a little emboldened,
mm,
saying, just told you, your case isn't that obvious.
mm.
I mean, you're not going to win, but means the other side's now a little bit more emboldened, and maybe the dollars being offered in the next settlement ain't going to be as high.
Yeah. So you're pointing out, something I think valid that I had not thought of, that there, even when you lose a summary judgment, may have some value to it. I think for, one of the best ways I can think about this or explain this to clients is, let's say you've got something that seems so, so clear to you, like you provided goods or services, you're owed the money, and you filed a suit on a sworn account, and it's just that simple. Here are the invoices. I sent the guy the goods, and he owes the money he hasn't paid. That's clearly a summary judgment. And I would submit to you that it might actually be a good summary judgment case. So let's say we file a traditional motion for summary judgment. We submit the invoices and an affidavit saying, hey, I'm the owner of this company. These are the true and correct invoices. We ship the goods to them. All the other side has to do to beat my traditional summary judgment motion is raise, one or two facts, something like, oh, well, the goods didn't really get to me, and the goods were sort of defective. And Chris, you're not going to believe this, okay? Sometimes the other party will lie. Have you heard of
I mean,
have you
I rock. I'm not at all.
I know that's So I explained that to the client. I mean, even if the goods were completely perfect and the defendant used them and never returned them and never complained, I mean, all the defendant has to do is sign an affidavit that's probably a lie that says something like, I ordered blue widgets and you shipped me green widgets, right? So, and there goes your summary judgment motion, and maybe you just paid us 5, 10 grand, whatever for that motion. And okay, well, we did it. And maybe there's some value in that, but it's really, it really has to be the right type of case. And I think these things get overused. Um,
There's lots of firms that it's just in their playbook. It's the next page of the playbook, and they say it's summary judgment time.
yeah,
Doesn't matter what case it is. The next page on the playbook says summary judgment time, so they file because they believe that's how it is. But like I said, a lot of times that's when you pounce is, okay, you're filing summary judgment in a case that's really not appropriate. Okay, great. I welcome that. I would love to go there, win. And now you have to go back to your client and tell them you just spent a bunch of money on summary judgment and you didn't get anything from it. So are you ready to come to the table now?
yeah, that's a good point. So now you talk about things being overused, and it's normally the big firm playbook that are just bilking the client to death, but that are just filing these summary judgments that don't have a shot of winning. But the ones that really, I think, have almost no chance of winning. I don't know that I've ever, maybe one or two in the 20 years or however long that I've practiced, I've seen a no evidence motion win. How many have you seen any no evidence motions granted?
I'm sure I have, but unfortunately I'm old and I've been too many motions and I can't
Yeah,
remember any particular,
the,
but
you can think about this as the put up or shut up motion, right? It's a no evidence motion for summary judgment. And you're basically telling the plaintiff, like, look, usually it's the plaintiff. I mean, but we've had enough time for discovery. We've done, there's not set time, but we've had enough time for discovery. And despite all the discovery back and forth, you haven't produced, is it a scintilla? Is it a scintilla standard? I can't remember. You haven't produced a scintilla of evidence that would support your claims. Okay. And yeah, I still see them, but you can imagine how high that burden is. If you're the plaintiff, and I guess you're alleging that you owe me money, you haven't produced one invoice, you haven't produced any text messages, you haven't even produced it's possible, I guess, but it's very unlikely. So
we see them in will contests. That's definitely of, hey, look, you're just contesting this will because you don't like it, and that a cause of action does not make. So come up with something showing the person didn't have capacity. Come up with something saying the person was unduly influenced, or go home. We've definitely had that. That's very common.
Yeah, that's a good example. Actually, I hadn't thought about that. That would be appropriate where the heirs or that were written out of the will just don't like it, which is not a reason. I don't like it. Mama never would have done that, right? And we're like, your no evidence summary judgment motion is basically going to say, well, mama did it, and you haven't, shown one thing. So that's might be a good use to it for. The important thing is the burden shifts to the non-movement to produce enough evidence. All right. So if you're bringing in the will contest case and you get slapped with a no evidence summary judgment motion, you've got to come up and produce. Now it's your burden, as Chris just said, to produce some evidence. There was, it could be an affidavit from a caretaker. Oh, she wasn't in her right mind. Something that would probably defeat a summary judgment, no evidence summary judgment motion. Okay.
And judges like to say that too. Like we were talking about, judges will like to say, well, may not be a strong case, but they got something. So let it go to trial. And again, they're trying to signal to you, hey, I don't think your case is all that strong. You might consider settling, but also not a summary judgment case. So adios.
Judges are masterful at trying to get cases out of their courtroom. They always seem, I can see myself doing that on the bench. It'd be like, you sort of half judge, half mediator. Like,
Of course, they love cases settling. They can't be open If the
Yeah.
case settles.
Yeah, that's right. So, all right, we got to move on. Let's talk about these rule changes that took effect March 1st, 2026. We're calling this the summary judgments are now on a shot clock. If I could explain the summary judgment process in Texas for as long as I've practiced, it would essentially, and attorneys would still, I don't know why they do this, but, and this is good for our young attorneys to learn. If you file a motion and you don't set a hearing, it just sort of exists floating in space without any kind of, action that needs to be taken. It could just sit out there forever. If you want the court to hear your motion, you have to set a hearing. And that's either an oral hearing or a hearing on submission, which is just a hearing on submission is just a fancy word, as the judge is just going to read it and make a decision in his chambers. Okay. So now, gone are those days, at least for summary judgment motions. And now, once you file the motion, we've got these deadlines. So if you get a summary judgment motion, you now have to file a response within 21 days after the motion's filed. Under the old rules, you would have 7 days after the 7 days before the hearing. Okay. So no more. So now you get your motion, 21 days, get a response on file. All right. Judges are now required to actually set hearings. So the judge can't just ignore it. So he's got to set a hearing within 35 to 60 days. And then the judge has to issue a written ruling within 90 days after the hearing. So the judges actually have to have their calendars and do something. Now, Chris, you're not going to believe this. There could still be a rule out there that says the judge has a hearing, has to do something within 90 days, and the judge could possibly not do it within 90 days. Is that believable?
Unfortunately, it is. I doubt there's any teeth to that, and I doubt we're going to start sanctioning judges for not following the rules. But at least it's there. We have to follow rules, so
yeah, you can
at least there.
You can file the made-up motion in Texas. As a judge, you're a little late. It's been like 6 months. Judge, pretty pleased with sugar on top. Would you rule on my summary judgment motion? Right? Okay.
Some like findings of fact and conclusions of law.
Yeah.
You can file them with your request that the judge enter findings of fact and conclusions of law, and the judge must enter it, I think, within 20 days. But if he doesn't, then you can file a motion reminding the court that they need to enter findings of fact and conclusions of law.
Reminder to do something, and it's a very gentle reminder, Judge, because you're the guy that holds my client's case. So very gentle reminder, Your Honor. So. All right, some formality kind of things. There's now a titling requirement, Chris. So you now have to call it traditional, no evidence, or combined, right?
Which we always did, but from my reading of the rule, there's actually more requirements in the title as to whether or not you want to hear it.
I mean, I don't know that. I think good attorneys would always try to help each other out and be like, this is a traditional. Some of them would just call it summary, and then you would sort of read figure out what is this. But now they title it. So,
or we call a hybrid motion because we want to sneak evidence into our no evidence motion for some reason.
That's a good strategy. You can still do that under the combined motion, and then it all just kind of blends together at the hearing. You have to include in the cover letter, the cover of the motion, you need to put a hearing request on it. All right. So
what does that mean? That's what I'm asking. Is that in the title of the motion?
No, I think I think your title, you have to have a title: traditional summary judgment motion, traditional motion for summary judgment, or no evidence summary judgment. You have to have a title, but then on the cover of the motion, you need to put a request for a hearing. Now, I think mechanically, Chris, my guess, okay, is you're going to call up the court coordinator and say, what hearing dates do you have available before maybe before you file, and then you would set it, or you just put it, or it's just a general request somewhere in the motion, and then you call and get the hearing date. I don't know, but.
Or it sounds like now the court's required to do it like on its own. So maybe that helps as well, because all courts are different. Some courts, you call, you set it, and then you file well enough in advance. And then some courts are like, no, you need to file, then we'll give you a hearing date. But Now it's saying, hey, you file, the court now has this specific timeline where they have to say hearing.
Yeah, that's right.
There's no arguing it. There's no way around it. They have to do it.
That's right. Okay. Also, under the new rule, you've got the right to file a reply. You don't have to, right? But if you get a you're the move it, you file your summary judgment motion, and then the other guy fires back with a response, and then you have the right to then file a reply to that response. 7 days. You've got 7 days after the response is filed.
Highly advisable to file a response if you do not want your case dismissed.
Yeah, you got to file. I mean, you don't have to, but yeah, you can go. You can just show up to the hearing with no response, and then
Unadvisable, ill-advised, because a lot of times the judge will look at you and say you didn't file a response, and
I know.
they'll look at you sideways and say, I don't know if I have to hear you.
Right.
I don't have anything writing from you.
I know. I'm definitely not recommending it, but so yeah, if you want to file a reply to their response, you can. And under the old rules, by the way, that was never a thing in the Texas Rules of Civil Procedure. A lot of courts would set a local rule, kind of cleaning that up, but now it's in the main TRCP rules. And then Chris, I don't know if you can do it or not. You've heard of a SIR. You just keep going back like a SIR reply, right? I mean, it's a reply to their reply. And at some point, kind of enough's enough. But
At some point, you should really question your life and you should stop.
Yeah.
But yes, I had definitely, there's motion, response, reply to response. If you then get into SIR replies, you need to go to bed.
yeah,
You
you need to stop. But you can. Maybe there's something you want to have. It's like when you're arguing with your wife, which is you're never going to win. Yeah. You got to have that last word so you can sleep on the couch. All right. So, all right. That brings our show to a close. We did good work on that. I feel like that. So, but we got to close this up. That brings
spring break. We're still at it.
That brings our show to a close. I've been your host, Phil Silberman. Chris Hill has been my very gracious co-host today. Like us, follow us, review us wherever you get your podcast. And as a reminder, nothing in the show is to be considered legal advice, and this has all been for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com and tell us you want it publicly answered in the podcast. Everybody have a great weekend.